but you have previously said this: I'm willing to accept that we who judge must not deny differences resulting from experiences and heritage, but attempt, as the Supreme Court suggests, continuously to judge when those opinions, sympathies, and prejudices are appropriate. So first, I'd like to know, do you think there's any circumstance in which a judge should allow their prejudices to impact their decision-making?
Never their prejudices. I was talking about the very important goal of the justice system is to ensure that the personal biases and prejudices of a judge do not influence the outcome of a case. What I was talking about was the obligation of judges to examine what they're feeling as they're adjudicating a case and to ensure that that's not influencing the outcome. Life experiences have to influence you. We're not robots to listen to evidence and don't have feelings. We have to recognize those feelings.
How is it appropriate for a judge ever to say that they will choose to see some facts and not others?
It's not a question of choosing to see some facts or another, Senator. I didn't intend to suggest that, and in the wider context, what I believe the point I was making was that our life experiences do permit us to see some facts and understand them more easily than others. But in the end, you're absolutely right. That's why we have appellate judges that are more than one judge, because each of us from our life experiences will more easily see different perspectives argued by parties. But judges do consider all of the arguments of litigants. I have. Most of my opinions, if not all of them, explain to parties why the law requires what it does.
Well, do you stand by your statement that my experiences affect the facts I choose to see?
No, sir, I don't stand by the understanding of that statement that I will ignore other facts or other experiences because I haven't had them. I do believe that life experiences are important to the process of judging. They help you to understand and listen, but that the law requires a result, and it will command you to the facts that are relevant to the disposition of the case. I knew that Justice O'Connor couldn't have meant that if judges reached different conclusions, legal conclusions, that one of them wasn't wise. That couldn't have been her meaning, because reasonable judges disagree on legal conclusions in some cases. So I was trying to play on her words. My play fell flat. It was bad, because it left an impression that I believed that life experiences commanded a result in a case, but that's clearly not what I do as a judge. It's clearly not what I intended. In the context of my broader speech, which was attempting to inspire young Hispanic, Latino students and lawyers to believe that their life experiences added value to the process.